IKB International versus Wells Fargo. Counsel?
Thank you. Good afternoon, and may it please the Court, Matthew Ingber from Mayor Brown for the Bank of New York Mellon. I'll be arguing today on behalf of all the appellants, and with the Court's permission, I'd like to reserve 2 minutes for rebuttal.
Yes, sir.
Thank you. In its divided ruling, the First Department ignored the plain language of the contracts, the carefully designed interplay between unambiguous contract terms, and the overall structure of the pooling and servicing agreements. Its ruling on Section 206 would collapse the well-settled distinction between the trustee's role before an event of default and after an event of default, and it would transform every one of the trustee's rights into duties without providing any guidance to the trustee about when, how, or under what circumstances to act. It would violate the rule that the trustee's duties are only those that are specifically set forth in the agreements.
Well, what specific rights were set out in Article 2.06?
So Article 2.06, or Section 2.06, refers to the rights referred to above.
Yeah, which rights?
The rights referred to above are all the rights that the depositor conveys to the trustee. That's in Section 201. There's the Article 2 in general is the conveyance of the trust fund to the trustee from the depositor, and the acceptance of that trust fund by the trustee from the depositor. That includes the rights that the depositor holds in the mortgage loans by virtue of its ownership of the mortgage loans. And then the trustee, as the holder of the trust fund, takes on all of those rights. It has all of those rights that are conveyed by the depositor and referred to in Section 201 of the PSAs.
And do you think that's spelled out?
I think rights referred to above would refer to all of the rights that precede Section 206. So that's 201, it's 202, it's 203. As I said, it does include all of the rights that the trustee has by virtue of being the owner of the mortgage loans.
And so it includes the rights to enforce the note?
It includes the right to enforce, yes. It includes the right to receive principal and interest. It includes the right to collect principal and interest. It includes the right to enforce repurchase remedies, but it's a right. It's not a duty.
So it says, though, exercise the rights. So what is the difference between exercising, an obligation to exercise the rights, or an agreement to exercise the rights, and holding a duty?
And I'm sorry,
Holding a duty.
holding...
Let's say that a duty and a right are different. Let's accept
Yes.
that for the moment. But this doesn't just say that the trustee has the rights. It says it agrees to exercise the rights.
So exercise does important work here, but the work is that 206 makes clear that when the trustee is exercising rights, it's exercising rights not for its own benefit, but for the benefit of certificate holders. It doesn't just say that the trustee shall hold the trust fund for the benefit of certificate holders. That's an important part of Section 206, and it embodies the trust law that says as the owner of the trust fund, the trustee can't put its own interests ahead of the interests of certificate holders. But it goes a step further, and it has to go a step further. It says if the trustee is exercising rights, not just holding the trust assets, but exercising rights, which it can do but is not obligated to do, it can't put its own interests ahead of the interests of certificate holders.
Well, when you say it can do but doesn't have to do, so suppose you have a winning lottery ticket, and you hand it to me and I say, I agree to exercise your rights under the ticket. Don't you think that obligates me to turn the ticket in?
In this Section 206, the trustee is agreeing to do something for a particular purpose. It's not always agreeing to do the thing. It's not transforming what is otherwise a right into a duty. And we know that not just because of those plain words in isolation, but also how those plain words intersect with the rest of the sentence in 206 and how Section 206 intersects with other provisions in the PSA. So for example, 206 says that the trustee agrees to hold the trust fund for the benefit of certificate holders and agrees to exercise the rights for the benefit of certificate holders. And in the very same sentence, it says it agrees to perform the duties set forth in this agreement according to its terms. So in the very same sentence, the drafters are using the word rights and they're using the word duties. This is not a logical way to draft this sentence if the goal all along was to transform rights into duties. So within the context of 206 itself, we can't conflate rights into duties. We can't transform what is a right.
So occasionally, some of these mortgages go into default, maybe more than occasionally, right? And
Right.
you hold the mortgages, the note holders have no idea which ones have gone into default, right?
No, they know what goes into default. Into default, the trustee on a monthly basis issues remittance reports, and they publish remittance reports on a
Okay, but
website.
that's information that you have first and you're giving to them, right?
Yes,
Let
it
me-
is
let me-
provided to the
right,
trustee
so
by the
let me get-
servicer
let me get to the
typically.
point. We've held that you have to provide, that is, if a mortgage is in default, you've got to provide that on a mortgage-by-mortgage basis, right?
That was the DLJ case.
Right.
Yes.
So how would the note holders do that? Can they do that?
Sure. There's a mechanism in the pooling and servicing agreements, Section 802 Romanet 4, that allows certificate holders with the requisite percentage of voting rights in the trust to direct the trustee
25%.
to take action. Yes, that's the mechanism.
What happens if only, 20% want to do that? The trustee has no obligation to do anything?
They don't have an obligation to. They certainly have the right to do that, and they can exercise that right, but they don't have the obligation to do that. And it makes sense to give the certificate holders the decision-making
Where I
over...
keep getting stuck is agree to exercise the rights. That's where I keep getting stuck.
Agree to exercise the rights for a particular purpose. When we think about the other provisions of the PSA, along with the language in Section 206, it would make no sense to transform those rights into duties. For example, Section 801, in a post-event of default world, the trustee shall exercise the rights that a prudent person would exercise. If those rights were duties all along, it would make no sense for the drafters to say in a post-event of default world, the trustee now has discretion to decide whether to exercise rights. That would make no sense. 8024, we talked about the direction mechanism, where we put in the hands of those with the sophisticated investors with the economic stake in the transaction, we put in their hands the right to instruct the trustee to exercise a right. That would make no sense if those rights were already duties. It also makes no sense to impose what could be an onerous duty to enforce in a section entitled Execution and Delivery of Certificates. It would make more sense to impose that duty if a duty to enforce existed in the section of the pooling and servicing agreement that actually refers to a repurchase protocol, refers to the idea of a party discovering a breach and giving notice of that breach to the repurchase obligors. But that's not what 206 does. It doesn't use the word enforce. It doesn't use the word repurchase. It doesn't specifically set forth any duty on the trustee. It doesn't give the trustee any guidance in determining whether, in determining how or under what circumstances it should exercise a right. I think under IKB's interpretation, it doesn't even give the trustee discretion to consider whether to exercise a right. It just has to flat out, according to their interpretation, exercise rights, convert those rights into duties. It would also be inconsistent with, and I see my time is up, but it would be inconsistent with Section 802 Romanet 10 of the pooling and servicing agreements, which say that the rights of the trustee to perform any discretionary act enumerated in this agreement shall not be construed as a duty. The drafters understood the distinction between rights and duties. They understood the distinction between the trustee's pre-event of default role, which is limited to ministerial functions, to those duties that are specifically set forth in the agreement, and the trustee's post-event of default world, a responsibility in a post-event of default world where they are obligated to now consider whether they should exercise rights. That's not even a mandate to exercise rights. In a post-event of default world, when the trustee's responsibilities are at their peak, what the pooling and servicing agreements say is that the trustee shall exercise those rights that a prudent person would exercise. So it gives the trustee discretion to think about which of these rights it should exercise. It is not a mandate to exercise those rights. In other words, it is not a mandated conversion of rights into duties like IKB's interpretation of 206 would be. I see I'm out of time. There's much more I could say.
Let me just ask then, under your interpretation, does that, somewhat along these same lines, under your interpretation, does that mean that the trustee could not exercise those rights under 2.06?
No, the trustee can exercise those rights. And if the trustee is exercising those rights, it has to pause and say, in the first instance, am I doing this for the benefit of certificate holders, or am I doing this to benefit myself? It could be.
So it's not obligatory, it's purely discretionary. Is that in part what you're saying is the import of this language?
Under their interpretation of 206, there actually is no discretion. The trustee is
Yes,
just
I got
supposed
that
to
point.
exercise rights.
Yes.
But in what we think is the proper interpretation of 206 and the PSAs more generally, the trustee can exercise rights. It's not obligated to. It may exercise rights. And if it does exercise those rights, it can put its own interests ahead of the interests of certificate holders. And so,
Does that mean it could not choose to act if it was contrary to what the majority of certificate holders wanted?
so it says that it has to
I know that's a
consider.
different provision about the 25%, but that's not what I mean
that's the thing.
here.
It has to take into account what is in the best interest of present and future certificate holders. That doesn't mean that doesn't necessarily mean that every single certificate holder will agree with the trustee's exercise of this right. They are certificate holders are placed at different stacks on the waterfall, as the court knows. But the import of 206, we believe, is to make clear at a time when the trustee, as the owner of the fund, is now distributing certificates to certificate holders. That's what 206 starts out by saying. You're distributing these certificates to certificate holders. You are still the holder of the trust fund. You can exercise rights, but when you do so, you have to do so not for your own benefit, but for the benefit of certificate holders. So there could be a right, for example, to seek mortgage loans. You could get a direction to exercise a right, a direction from certificate holders to exercise a right to seek mortgage loans from the repurchase obligor, to investigate whether there were breaches of representations and warranties. But if the trustee knows that the certificate holder is giving that direction not to benefit the certificate holders as a whole, but to benefit itself, to pursue some separate fraud lawsuit, an individual direct action against the seller or the sponsor. That's not for the benefit of certificate holders as a whole. If the trustee is carrying out a right because it wants to line its own pockets at the expense of certificate holders, that's not permissible, and that is the import of 206. It is not a duty-imposing provision, certainly not a duty-imposing provision that that mandates that the trustee enforce repurchase remedies that may exist.
Thank you.
Thank you.
If it please the court, John McFerrin Clancy for respondents, the IKB entities. Just picking up on the questions to defendants' counsel, I think part of the problem with the defendants' reading of this text in 206 is that they conflate rights and duties. They don't really seem to have it quite correct. The rights referred to there are the rights of the trust. The duties are the duties of the trustee. Right? That's really, I think, the key distinction here. So when you read this, yes, as the section says, the trustee has many duties, and there are various rights throughout the agreement, rights of the trust. And the question is, when and if the trustee has an obligation to exercise particular rights. Here, notably, this section 206 doesn't speak to every right of the trust in the PSA or with regard to other agreements with other parties. It only says the rights referred to above. So with regard to those rights of the trust, which counsel has admitted includes repurchase rights, the trustee agrees, right, as has been pointed out, words of commitment to exercise those rights. And so it seems clear just from the text alone that the intendment of this section is to ensure that when repurchase is called for, that the trustee will do so.
Counsel, I'm sorry, just a very basic question, if you could help me with. When is the repurchase right, duty, whatever it is, when is that triggered?
Was litigated below, actually, in the first department, in the decision below, and the conclusion of the first
You
department.
don't need a default on the mortgage. I mean, I assume there's a number of mortgages that are going to default that, you know, the reps
Yes.
and warranties weren't bad.
Well,
you know,
with the mortgage,
default.
you are in the section 202 scenario, which is mortgage file defects, there's a schedule where upon receipt, either the trustee or someone acting on behalf of custodian actually inventories what's in the mortgage files, generates particular reports, and then sends them back, and it generates a demand to cure based on that. How soon
And
after?
based on- So what would they find, and I'm just
Sure.
curious, what would they find in the file that would trigger the repurchase protocol?
Things they wouldn't find, like an allonge, right, or the proper assignment, or the note, right, certain servicing files necessary for the servicing of the loan. There's a list, there's a schedule at the end of most of the PSAs that sets out with it, and so it's a checklist. And after that, as the first department's most recently held, the trustee has a reasonable time to bring suit with regard to non-conforming loans. To take up on some of the defendant's other points, there's no conflict between this idea that the rights in Article 2, which are the only rights we're talking about in 206, because it's only what's above, right? It's 201, 202, 203, are inconsistent with other portions of the agreement. For example, in Article 8, Section 801, where it talks about the prudent person duties. If you actually read the full text of the section, of that sentence, it's, upon events default, the duties include, and a prudent person duty will be imposed, right? So in other words, what that sentence is saying is not that there aren't duties beforehand, including duties for repurchase.
Well, are the duties beforehand less than a prudent person would have?
They turn on by and large, for rep and warranties, Your Honor, they turn on awareness. As Your Honor will now recall, this court's prior holdings and in Commerce Bank in the first department, the holding was you must show loan-by-loan knowledge that the loans are non-conforming in order to have a pre-EOD claim. So in other words, if we wanted to, for our pre-EOD claims, we'll have to show that the trustee was on notice on some PSAs or actually aware in other PSAs that the loans were non-conforming. So you're going to do it one by one. In mortgage file defects, that's easier because there's a schedule generated by the trustee. So the trustee is well aware of all of the schedule defects. So the standard is higher, right? The proof is different when an EOD has occurred, but it doesn't change the fact that there's a pre-EOD duty expressly set forth here.
So do you agree with his position regarding your interpretation, that, and maybe you've answered this and I just missed it, so my apologies, that that would mean that it is a mandatory exercise, there's no discretion regardless of the fact that it may actually be detrimental to the majority of certificate holders?
It's difficult to see in the first instance. Well, the short answer is yes. There's no discretion here, right? And there are two reasons. First, it's hard to see how forcing a a seller, the responsible party, to put money back into the trust for a non-conforming loan hurts any of the certificate holders. It should benefit those who are most senior, which is appropriate, and then depending on how many loans get repurchased, that money will flow down the waterfall to the benefit of the subordinate certificate holders. But also, to come back to a point, and I think this is why, we put some emphasis on the U.S. Bank v. DLJ decision from this court in our brief, and I think it's really appropriate as to understanding how this works practically, right? I mean, for example, so I think the language here, I say on its face, calls for non-discretionary exercise of repurchase rights, the rights set forth above in Article 2. But the kind of, but as this court said in DLJ, you also read the text in the context of its purpose. These are residential mortgage-backed securities. The mortgages are everything, right? So the idea that someone's going to invest millions, tens of millions of dollars in certificates backed by mortgages without, where the key thing is, do they have the mortgage file? Can they actually go out and enforce mortgages and foreclosures? Can they, do the mortgages actually look like they're supposed to? They have the collateral characteristics and risk profile that was identified in the reps and warranties. The idea that, if
Counsel, isn't that position in your expressly set forth argument somewhat, to say the least, undermined by the other agreements that do expressly provide for this duty?
I don't think so, Your Honor, for a couple reasons. First, these are, the classic situation is, you're all in one big transaction or related transactions, and different agreements say different things, and the court reads them together and harmonizes them.
No, but I think we've done more than that in these cases, right? We've looked to other agreements to see I mean, these are not individual little investors. I mean, these are big institutions who are signing these agreements. So,
Well, some, I mean,
in another agreement you have this, in this agreement you don't have this.
I think, Your Honor, I'm sorry, I didn't mean to speak over.
No.
I think, Your Honor, if, we're talking about 95 trusts here. I think if 94 of them said had expressed this right in one way, and we're talking about one trust that's an outlet that writes it a totally different way, I think that would be a more powerful argument for the defendants to say, hey, this is the one time where they said, hey, we really want to do it differently. But as we lay out in our brief, I mean, about a quarter, there's 3 or 4 different ways that different lawyers in different transactions pulling down different, different forms from their office systems have articulated what is essentially the same right. And so I think that the notion that, well, yes, in 20-odd deals here they did it this way, and 30 deals they did it that way, I don't think really tells us, I don't think it informs that much what this text means.
Do you know how many had that provision here?
The provision at issue today?
The provision that we were just talking about that gives that puts the specific duty on the trustee to act the way you think they ought to act.
Well, I think there are 25 that have 206 like this. And then in the beginning of our brief, I think there are about 30 that use the phrase shall enforce. I believe it's about 30. I don't have the, I'm sorry, I should have memorized those figures from the, but it's early in on our brief. And then there's another iteration for, I think, another 26 or so. That have yet a different phrasing in these relevant sections in Article 2.
But what you're sort of saying is that one law firm might prefer shall enforce and another might prefer agrees to enforce, and you shouldn't infer a difference from that.
Yes, Your Honor, exactly.
But it's very different import of the language, right?
Well,
It's not, I mean, it seems a bit more than a preference to me. I mean, it seems like a legal implication.
well, I think, Your Honor, if you get, I think the starting point still needs to be, what does this text say? And I still think that when you say that I agree to exercise the rights above, then in fact you are bound to exercise the rights above. There are other ways to say it, and believe me, and as you see from other arguments that were raised here, their argument under 3.05, right, where they talk about how there's a provision, section 3.05, that says even post-EOD, when the trustee has to take over the role of the servicer, it's not required to, it's not required to make repurchases. But that's, in fact, when you look at that, that's a clause that really relates to situations where the servicer is also the responsible party. And it's just making clear that in those cases, the trustee doesn't have to actually repurchase loans, even though it's otherwise stepping into the servicer's shoes. Now, that's not the case in this trust, right? And so, I think it was Justice Barak in the Finkelstein case who noted that, these are cut and paste a lot of times, the way the corporate lawyers put them together. So sometimes you see phrases here or there that don't necessarily jive. So, again, I don't think that you need to overread how these things are put together.
Your red light is on. You want to address the no action clause?
Yes, thank you very much, Your Honor. Very briefly, every court to consider the issue, including this one, has stated it is absurd to ask a trustee to sue itself. They make a severability argument and say, well, but then you have the 25% piece of the no action clause. The problem with that, they read the 25% to say, well, sure, it's absurd for you to do it, but if you have 25% of the holders give you permission, then you can move forward and bring your suit. It's not what the clause says, right? When you read it, it says that the 25% will also make the same demand. In other words, there's nothing to sever here. What the clause requires is that a certificate holder make a demand and 25% of the certificate holders also make that demand. So it's just as absurd to demand it of the 25% as it is to demand it from a single certificate holder. So I think the argument there is it just doesn't work as a matter of text. And I will say that, for 14 years, defendants argue that the clause, that the language in quadrant is dicta, where this court notes that no action clauses don't apply to claims against the trustee. I don't think it's dicta. I think it's a part of a careful, reasoned argument. But even if it is, every court to consider that over the last 9 years has held the same way. Parties filing a suit have relied on that. And so the idea that now, even though I think the text is completely against defendants, that suddenly that's going to be reversed, I think that's the kind of precedent with tremendous reliance, where the court has to be particularly persuaded that defendants are correct to overturn it. Thank you. May I have 15 seconds on the last issue in the case. With regard to whether or not our independent tort claims can be maintained, defendants put a lot of reliance on the dormitory authority case. That case is very different. Factually, it's about an architect being sued for a building that collapsed. And the parallel claim there, one was breach of contract, the other was negligence for failing to meet professional standards. So it really was just the same violations, just recast. Here, we talk about breach of fiduciary and conflict of interest, and we note that there are discretionary things, as counsel points out. A lot of things in the PS are discretionary, whether to send notices, whether to replace the servicer. And if, for example, a servicer ought to have been replaced, but because of a conflict of interest, the trustee decided not to replace the servicer, that could generate additional damages, losses of principal interest, and other types of damages. So we think that it's truly has a separate basis legally and generates cognizably separate damages. Thank you, Your Honors.
I have 3 points. First, Mr. McFerrin Clancy says that awareness is the watchword in Section 206. The word awareness doesn't show up in 206, and this proves our point. It doesn't show when, how, or under what circumstances there is a supposed duty to enforce. If we compare 206 to provisions that actually impose a duty, it's pretty stark, the difference between a duty-imposing provision and one that's not. Section 202, the trustee agrees to deliver at 10 a.m. on the closing date initial certifications. 90 days after closing, shall deliver to these specific parties a final certification. Second point, Judge Garcia, the shall enforce trust established 2 points. Number one, the drafters knew how and where to impose a duty to enforce if that was the intention. They placed the shall enforce language in the section of the pooling and servicing agreements that refers to repurchase, that has a protocol for giving notice if there's a breach of a rep and warranty that has a material and adverse effect on certificate holders. That makes sense. It also makes clear, we think, that 206 can't mean what IKB says it means because it would be redundant of the shall enforce language. Those shall enforce trusts have both 206 and the shall enforce language. And then with respect to the no action clause, the condition that 25% or certificate holders with 25% of the voting rights support the action, in this case an action against the trustee, makes sense and is supported by the contract for a variety of reasons. Number one, applying that condition gives meaning to the language in the no action clause that certificate holders covenant to one another. Each certificate holder covenants to the other and to the trustee that if they are seeking to enforce a right under the contract, they're doing it for the benefit of all certificate holders. Just as the trustee, if it's exercising a right, has to do so not for its own benefit, but for the benefit of certificate holders as a whole, so too with respect to certificate holders. So it gives meaning to that language. Applying that condition gives meaning to other provisions of the pooling and servicing agreement. The 25% direction mechanism in Section 802 Romanet 4. It acknowledges the collective action concept in the PSAs. 25% need to give notice to a...
Counsel, let me ask this. In an ordinary case where you're asking the trustee to sue a third party, and the clause kicks in, and there's a lawsuit and it's unsuccessful, the costs come out of the trust, right?
If the trustee is directed to pursue a claim on behalf of the trust, yes, that is a cost to the trust.
In a case like this, where this party sues the trustee, who pays for the cost of the suit if they lose? Trust or the party bringing the suit?
Well, it depends on the language of the pooling and servicing agreement and specifically the indemnity language, but in many of these trusts, the trustee is entitled to indemnity, absent willful misconduct or bad faith. And that's the cost to the certificate holders. They are bearing the cost of this litigation and not benefiting from any of the recovery.
This case today, they're bearing the costs of this litigation here today?
The certificate holders, the trustees are, are entitled to get indemnity from either the trust or in some cases from the servicer, who is then entitled to reimbursement from the trust. So the answer is yes, certificate holders are bearing the expense of this type of litigation, and they're not benefiting from the recovery. And it's not just...
If they win, why aren't they benefiting from the recovery?
Because the damages, if any damages are to be paid, and I don't think that has happened in any of these cases, but it would go to IKB and only IKB. The other harm to certificate holders is that you have a single certificate holder taking positions on the role of the trustee that other certificate holders might not agree with. And so applying the condition in a case like this serves the policy goals behind no action clauses more generally. And one of those goals is to give certificate holders a significant say in litigation that will affect their rights and potentially their recovery.
Just so I'm clear, counsel, if you were to prevail in this suit, you can recover your costs and get indemnified for that related things from the trust?
It depends on each specific pooling and servicing agreement or indenture, but there are many that provide, on page 25 of our reply brief, we cite to a pooling and servicing agreement, 805 of the pooling and servicing agreement, that says the trustee shall be entitled to indemnity from the trust fund. There's carve-outs for willful misconduct and bad faith, but yes, that's what the contracts say, and that's the contract that these sophisticated investors...
So then, just following up on that carve-out, if indeed the basis of the claim is bad faith or professional misconduct or some other breach that might fit within that language, then there is no indemnification for the trustee, right? They're not going to get indemnified for defending their bad acts. If a court concludes there were bad acts.
Sure. If a court concludes that there were bad acts that fall into the carve-outs, then yes, I agree, it would be difficult for the trustee under those circumstances to seek indemnity, for example, for damages that it would have to pay if there is a specific finding, for example, of willful misconduct. But there hasn't been such a finding in these cases, and in the meantime, we have individual certificate holders who are taking positions that may well be inconsistent with the views of other certificate holders, and really they're making an end run around 802 Romanet 4 of the pooling and servicing agreements. I've mentioned that provision a few times now, but that, as I said, allows certificate holders to direct the trustee. If they have 25% of the voting rights, it allows them to direct the trustee to exercise a right, to take action, to file a lawsuit, to conduct an investigation. If we don't apply the no action clause here, a individual investor with, say, 0.2% of the voting rights of the trust can choose not to direct the trustee and instead turn around and sue the trustee for not taking the action that these PSAs didn't give them the ability to direct the trustee to take. And that's problematic from a contractual standpoint and from a policy
I
standpoint.
thought the argument of your adversary was, in the ordinary case, again, with a third-party target, let's call it, there is a risk to the trust. The trust potentially can lose money, so therefore 25% critical mass would be needed to take that risk, let's say. But in this case, there isn't a risk to the trust. I thought that was their argument.
I think there is risk to the trust. That's where we disagree. We talked about the indemnity that the trustee is entitled to. That's a risk to the trust. It is a risk to the trust if IKB is taking a position that is at odds with the position that other certificate holders have with respect to the role of the trustee. And that has the potential, long-term, to increase the administration costs associated with these trusts. And that's what the ABA brief focused
Under
on.
your interpretation of the PSA, what would happen if 25% or more of the holders of certificates asked the trustee to sue the trustee?
So we agree that the trustee cannot sue itself, but sending that request itself is not absurd, right? The trustee suing itself is not something that can happen.
You get that request from 50% of the
get the
holders, and then what happens?
So the trustee says no, or the trustee doesn't respond, and then within 60 days or after 60 days, the certificate holders can then sue the trustee. So there's no harm.
The trustee can't say yes, right?
The trustee can say yes, but there is value to the trustee in getting a communication that serves two purposes. Number one, it tells the trustee that certificate holders think the trustee has done something wrong or should be doing something different. And that's especially important in a post-event of default scenario. And number two, it communicates that a sufficient number of certificate holders or certificate holders representing a sufficient percentage of voting rights want action to be taken against the trustee. It allows the trustee and the certificate holders to communicate, to try to resolve their issues, to have the trustee take action that the certificate holders think the trustee should be taking, potentially staving off litigation. So there is value to the trustee in getting that request and knowing that there is sufficient investor support behind it, and there's no harm to the investors in sending it, because if the trustee says no, because it can't sue itself, if they have 25%, they can go ahead and sue the trustee, assuming the other conditions are
I don't understand that other
satisfied.
flip side of the argument you made, that in response to Chief Judge Wilson, that the trustee could choose to sue itself. When would it do that? Isn't that an admission of having
No, I don't.
violated whatever, based on the claim, violated whatever responsibility the trustee had?
I don't think the trustee can sue itself.
Okay, oh, I'm sorry. I thought
I'm
you
sorry
said
if
that.
I
No,
misspoke.
I thought
I
you
don't
did
think the
say that.
trustee can sue
Okay,
itself.
okay.
But as I said, there is value in getting that request, and more importantly, we're focusing on the 25% condition. Before even sending a request, certificate holders have to amass 25%. In our view, and we think it's supported by the contract and just the goals behind no action clauses, is that is a separate condition. If they can check that box, then assuming the other conditions are satisfied, they can go ahead and sue the trustee. And 25% is the measure of sufficient support. Right? The language says that certificate holders must act for the benefit of certificate holders as a whole. That 25% is the percentage that the drafters came up with as the measure for what will benefit certificate holders as a whole.
Thank you.
Thank you.